On 16 December 2016, the notification regarding that first state level selection test for recruitment of assistant teacher 2016 in physical education and work education was notified. Now, we all know that this 26,000 set aside, division bench, all these things. This was Group C, Group D, 9, 10, 11, 12. If you kindly, Mr. Dasgupta, please show him page 81 of the division bench judgment. Yes. What I am getting from here, Group C, Group D, was the selection was in terms of rule of 2009.
No.
Right?
Group C, Group D, 2000. Yes, that was 2009.
2009.
9, 10, 11, 12, 16.
2006.
No, it's a printing mistake.
Oh, it should be 2016.
16.
Right. And this is also 2016.
Yes.
Mr. Dasgupta, have you supplied these two rules to me?
Yes, that's a part of the petition.
Also,
This is also part of the.
no, 19.
No, 19.
My lord, the rules for 19, 11, 12, Group C, Group D have supplied hard copies as well as soft copies.
Hey, Group C, Group D এটা বার করুন, এই দুটো আমার দরকার।
আমাকে দাও তবে।
Mr. Bhattacharyya, why I am looking for this? Because on the analysis of these rules, the division bench affirmed by the Honorable Supreme Court that there was infraction of rules in conducting the selection process apart from other allegations. Parameteria. So, the way you are interpreting now the 2016 rule, please take me to that portions where I will be getting some kind of similar, not now, according to your time, whatever way you have prepared yourself.
Follow.
So I need to compare it. If these areas have already been dealt with by the division bench, affirmed by the Supreme, my task will be rather a little bit easier.
No, I will ultimately take your lordship to that.
Very well, very well.
Now, before taking your lordship to that, I want to also demonstrate the entire issue about the creation of post.
Very well, I understand, but I was wondering to that.
Yes.
Now, please take this notification of 16 December 2016.
Yes. That is, yes.
Let me read it for you. As per instruction, reference number such and such dated 20th September 2016. This is the notification whereby the rules called West Bengal School Service Commission selection for appointment to the post of teachers for upper primary level of schools rules 2016 was framed. This is that rule. Now, what is this notification is saying? As per instruction wide reference number, this is the 2016 rule of the government of the Department of School Education, Government of West Bengal, that is West Bengal School Service Commission, selection for appointment to the post of teachers upper primary to rules 2016. The West Bengal School Service Commission has been designated to conduct state level selection test for recruitment of assistant teachers in physical education, work education in recognized non-government aided sponsored school in West Bengal. Very important, against the vacancies available under the 2016 rules.
Well, that was I was harping that 2016 rule itself delineates the methodology of finding out the vacancies.
So, can I take it that notification date is 16 December 2016 when the employment notification was issued? Then it was made clear to everyone that vacancies will be against the vacancies available under the 2016, meaning thereby as per rule 8.
Right. So there's no doubt in it, and no can question it. Now, I was just trying to demonstrate because in the state affidavit they have taken this plea that we have administrative power. Therefore, I have taken issue to the constitution and the administrative power, to what extent state can do it and whether they can do it in violation of rules. To that extent, I am not trying to develop it. Now, the last day, I was placing this judgment 2010, volume 6, Supreme Court cases, page 777. This specifically relates to the recruitment.
2010 volume 6 777 কালকে লাস্ট যখন শেষ করার সময়
And my lord would be pleased to find the honorable judges, while deciding this matter, in fact had the privilege to consider all the judgments delivered by Supreme Court so far. That it's a very rare occasion that they have considered almost 25 judgments
by the division bench or the Supreme Court?
by the Supreme Court. I am now citing 2010 6 Supreme Court cases.
দাঁড়াও, এক মিনিট। এটা রাখো। The other thing I'm making it clear, and I have already made it clear, that in view of the fact that the Soweto state candidate since has already been recommended for appointment, that issue I'm dealing with now.
Yes, Lord,
Without detaining the other
my
issues.
lord has made it very categorically clear that my lord is considering, Lord, the
Challenge
creation of supernumerary posts and other things.
And maintainability to that.
And not beyond, my lord, the main challenge to the
Main
entire
challenge,
panel. I'm not.
very well. Yes, now today, খাতা কোথায় আমার?
2010 volume 6. Because otherwise, my lord, the ratio.
Yes, will be difficult to understand.
Paragraph 2. The facts and circumstances giving rise to the present appeal are that in order to fill up 15 posts of junior clerks in the district Sonepur, applications were invited by an advertisement dated so and so. The advertisement made it clear the number of vacancies could be increased. The respondents applied in pursuance of the said advertisement along with a large number of persons, and written examination was held in accordance with the recruitment rules. Before the selection process could complete, the number of vacancies were increased from 15 to 33, and as per requirement of the 85 rules, a merit list of 66 candidates was published. The appointments were made on the said posts. Identical feature. The respondents whose names appeared in the merit list and could not be offered appointment, being much below in the merit list, filed applications before the tribunal praying for a direction that the state to offer them appointments. The tribunal, vide its judgment and order dated so and so, came to the conclusion that appointments were to be offered to all the candidates if the entire select list stood exhausted. Therefore, the tribunal directed to offer appointment. We have same plan. We are agitating, we are waitlisting, therefore we have to give appointment. Then, but I am skipping over, my lord, the respective arguments. Then kindly come to, my lord, paragraph 9.
No, here the little distinction what I am
They
getting.
were in the merit list. Here. In our case, they were in the waiting list.
And the vacancies were increased from 15. Vacancies were increased.
Before the selection we could make. That's the interesting part. Now kindly come to 9, paragraph 9. If the aforesaid relevant rules are read together, the cumulative effect therefore comes to that after determining the number of vacancies, taking into consideration the expected vacancies, the same shall stand notified to the local employment exchange and advertise the same through other means. Here, Mr. Pilot was putting me the question at the beginning that the vacancies were identified, thereafter the notification was published. Same thing. The select list after holding the test as required under the 85 rules shall be prepared and published, which shall contain the names of candidates, double the number of vacancies to advertise and determine. Here, Milord, 1.14. There was double. Rule 14 merely enables the state government to relax the eligibility conditions by recording reasons in respect of any class or categories of persons in public interest. Rule 14 empowered that. Here, there's no such empowerment rules. Now, it's important. It is a settled legal proposition, paragraph 11, that vacancies cannot be filled up over and above the number of vacancies advertised. Kindly highlight this. As the recruitment of the candidates in excess of the notified vacancies is a denial and deprivation of the constitutional right under Article 14, read with Article 16(1) of the Constitution, of those persons who acquired eligibility for the post in question in accordance with the statutory rules subsequent to the date of notification of vacancies. Filling up the vacancy, the question of locus, your lordship probably is being always. Now, this is a clear answer. Even the persons who were waiting might have been qualified, their rights are affected. Therefore, they have also locus. Filling up the vacancies over the notified vacancies is neither permissible nor desirable for the reason that it amounts to, quote, improper exercise of power, and only in a rare and exceptional circumstances and in emergent situation, such a rule can be deviated, and such a deviation is permissible only after adopting policy decision based on some rationale. Otherwise, the exercise would be arbitrary.
Here the policy decision taken.
Again, read it. I'll let you complete. Filling up the vacancies over the notified vacancies neither permissible nor desirable for the reason that it amounts to improper exercise of power, and only in a rare and exceptional circumstances and in emergent situation, such a rule can be deviated, and such a deviation is permissible only after adopting policy decision based on some rationale. Otherwise, the exercise would be arbitrary. Then, filling up of vacancies over the notified vacancies amounts to filling up of future vacancies and thus not permissible in law. This is the declaration of law. That the portion which I was reading is a quotation of some documents. And there the court says, filling up of vacancies over the notified vacancies amounts to filling up of future vacancies and thus not permissible in law. The Supreme Court judgments referred to. Then paragraph 12, in state of Punjab versus Raghuveer Chand Sharma, this court examined the case where only one post was advertised and the candidate whose name appeared at serial number 1 in the select list joined the post, but subsequently resigned. The court rejected the contention that the post can be filled up by offering appointment to the next candidate in the select list, observing as under, quoting from SCC that page, with the appointment of the first candidate for the only post in respect of which the consideration came to be made and select panel prepared, the panel ceased to exist and has outlived its utility, and at any rate, no one else in the panel can legitimately contend that he should have been offered appointment either in the vacancy arising on account of the subsequent resignation of the person appointed from the panel or any other vacancies arising subsequently. But here the vacancies did not arise, was created subsequently.
Panel ceased to exist.
Yes. Therefore, the judgment on the issue is absolutely watertight. Then paragraph 14.
Just a minute.
Yes.
So notification is highly. Yes.
Paragraph 13. In Mukul Saika, a state of Assam, this court dealt with a similar issue and held that, within quotation from that judgment, if the requisition and advertisement was only for 27 posts, state cannot appoint more than the number of posts advertised. The select lists got exhausted when all the 27 posts were filled. Thereafter, the candidates below the 27 appointed candidates have no right to claim appointment to any vacancy in regard to which the selection was not held. Here, no selection, nothing. I create post, give you offer. I don't want to tell you the background history. Because I am court of law, constitutional court of law, I just will not give you the constitutional facts. The currency of select list had expired as soon as the number of posts advertised were filled up. Therefore, appointments beyond the number of posts advertised would amount to filling up future vacancies. And the said course is impermissible in law. A person whose name appears in the select list does not acquire any indefeasible right of appointment. Empanelment at the best is a condition of eligibility for the purpose of appointment and by itself does not amount to selection or create a vested right to be appointed. Lord, the whole claim of the so-called wait-listed candidate is that we have a right to be appointed. And since posts were created for us, therefore, court is not supposed to interfere. That's the Willard's argument. The vacancies have to be filled up as per the statutory rules and in conformity with the constitutional mandate. Then, my lord, paragraph 15. A constitution bench, what will be surprised to find when the short judgment, the Honorable Supreme Court had considered almost 25 judgments on the whole issue. And then says, a constitution bench of this court in Sankarshan Das of the Union of India held that appearance of the name of a candidate in the select list does not give him a right of appointment. Mere inclusion of the candidate's name in the select list does not confer any right to be selected, even if some of the vacancies remain unfilled. But where the vacancies remain unfilled, there also Supreme Court says you cannot do this. And here you create vacancy. Well, I am confining again law to the constitutional legal authority of the state to create vacancies to accommodate a particular group. Mere inclusion in the candidate's name in the select list does not confer the right to be selected, even if some of the vacancies remain unfilled. Well, this is more important. The candidate's concerned cannot claim that he has been given a hostile discrimination. Reference of various judgments given. Then paragraph 16 is the verdict. A select list cannot be treated as a reservoir for the purpose of
This has been quoted, I suppose, in the judgment of the division bench.
Well, all these I had cited.
Is a perennial source of reservoir, presidential reservoir.
A select list cannot be treated as a reservoir for the purpose of appointments. That vacancy can be filled up taking the names from the list as and when it is so required. It is a settled legal proposition that no relief can be granted to the candidate if he approaches the court after the expiry of the select list. If the selection process is over, select list has expired, and the appointments had been made, no relief can be granted. But he had admittedly selection was over.
Panel expired.
Panel expired. 2 years thereafter, without the cabinet thought that we shall 3 years after create posts. Why? Purpose is very clear: to quell the administration. Demonstration. And those assurances were given again. My lord will kindly excuse me if I take a little digression before an election. Then next paragraph. I read it better. The instant case is required to be examined in view of the aforesaid settled legal proposition. The 1985 rules provide for determining, which my lord was asking, determining the number of vacancies and holding competitive examination ordinarily once in a year. The select list prepared so also is valid for 1 year. In the instant case, 15 vacancies were advertised with a clear stipulation. The number of vacancies may increase. The authorities had taken a decision to fill up 33 vacancies. Thus, a select list of 66 persons was prepared. It is also evident from the record that some more appointments had been made over and above the 33 determined vacancies. Thus, once the selection process in respect of number of vacancies so determined came to an end, it is no more open to offer appointment to persons from the unexhausted list. Then it's important. It is the exclusive prerogative of the employer. Here below, the appellant was the state. Not like us, where state is not defending. Where the state went up challenging the direction of the tribunal, how could you direct appointment? Therefore, my lord, the Supreme Court says it is the exclusive prerogative of the employer, that is state administration, to initiate the selection